Good morning, everybody. Welcome you to the Licence and Regulatory Committee here on the 8th of July 2016. This will be live streamed and recorded, so what we'll do, we'll introduce ourselves in a moment, but the procedures for the meeting will be we'll introduce ourselves and then Ruth Falk and Mandy Messel will go through introductions, and Mandy will do a presentation, and then we'll make our recommendations with our reasons applied to our recommendations for our decision today with regard to the definition map modification order of Cleddon Chute and in Llandogo Trelech. I think as we go through the presentations, Mandy is open to questions and any clarifications as well. So I'll introduce myself now as Linda Guppy, Chair of Licensing Committee today.
Nicola Perry, Senior Democracy Officer.
Claire Williams, Legal Services.
Mandy Mussell, Definitive Map Officer.
Ruth Falk, Principal Countryside Access Officer.
Jim Higginson, Member of this committee.
Brian Strong, a member of this committee.
Martin Hickman, member of this committee. Councillor John Prosser, member of the committee.
Phil Hobson, Deputy Leader, Cabinet Member for Community Development, which includes Countryside Services.
And just for clarification, for procedures today, a Cabinet Member will not be included in our decision-making process today. We won't be part of our vote and recommendations. Can we have any apologies of absence, please?
Yes, we've received apologies from County Councillors Ruth Edwards, Anne Webb and Francis Taylor.
Have we got any declarations of interest? No, thank you. Okay, well, I'll hand over to the officers now. If you would like to open it out, Ruth. Thank you.
Yes, good morning, everybody. Mandy and I are here today to present the relevant evidence and legislation relating to two modification orders. This matter involves Cart Road Bridleways 20, 21, 22 and 23 and restricted byway 24 in the village of Llandogo in the community of Trelech. The presentation takes about an hour and a half to finish, so I hope you'll bear with us. As you know, we've got to go through all the evidence with you, and Mandy will follow on in a moment with that. But just to start, there's a few things to run through. There's authorities acting in a quasi-judicial capacity, and they must reach a decision based on the evidence presented. We're not required to resolve conflicts in the evidence, and there may well be evidence on both sides of the issue. We must weigh up the evidence using the test of the balance of probabilities, and if on this balance it is reasonable to conclude that the evidence shows that change should be made, we must do so. Although we have considered the evidence as officers and made a recommendation, you as members must consider the evidence and reach your own conclusion. If a modification order is made, anyone has the right to object, and the matter would be determined by the Planning Inspectorate for Wales. This plan is the applicant's submission that shows the section of the route in question between A and B. The applicant believes this section has higher public rights than that currently marked on the definitive map. As research for the Cart Road Bridleways CRBs 20 to 23, that's A to B, was undertaken for the applicant's claim, best practice guidance requires that the whole route which continues as restricted byway 24 should be investigated to point C as part of the claim. The report discusses in detail the symbol and the use of the terms road used as public paths, often known as RUPs, and the use of non-statutory symbols for Cart Road Bridleways CRBs and Cart Road Footpaths CRFs. In considering this matter, the committee cannot take into account need, nuisance or suitability. Case law states that an authority must look at all available evidence before making a decision to either make orders to record all routes as public footpaths, as recommended, or, if you consider there is sufficient evidence to make one order and not the other, or again, if you consider there is insufficient evidence to not make both orders. If the orders are made and current objections are sustained, then the matter would be passed to the Planning Inspectorate, who would decide whether or not the order can be confirmed. The Planning Inspectorate would advise the parties involved of their decision. So the legal legislation that we're using is the Wildlife and Countryside Act, Section 53(3)(c)(ii). And which says on the discovery by the authority of evidence, which when considered with all relevant evidence available to them, shows that a highway shown in the map and statement is a highway of a particular description ought to be there shown as a highway of a different description. So the types of highway recorded on the definitive map and statement are footpaths allowing walkers only, a bridleway allowing walkers, horse riders, cyclists and possibly the right to drive cattle, a restricted byway allowing all the above, including a horse-drawn cart, and a byway open to all traffic, allowing all the above, including motorised vehicles. In this case, the applicants wishing to verify vehicular access to their property, section A to B, submitted the claim to upgrade the registered route to a byway open to all traffic. The definitive map can be corrected, but the correction is dependent on the discovery of evidence. So the current recorded alignment on the definitive map is marked by a broken green line, which is a symbol for a road used as a public path, along with the reference Cart Road Bridleway. Therefore, the route in question is essentially recorded as a public bridleway. The 2000 Countryside and Rights Way Act, Section 47, came into force on 11th of May 2006. And the 2006 Natural Environment and Rural Communities Act, often known as the NERC Act, came into force in Wales on the 16th of November 2006. The subsections under the NERC Act do not apply to the route in question, Part A to B, but have changed the status of that Part B to C. So that's why we have got two orders, A to B and B to C. The applicant's evidence report submitted in support of the claim consists of 13 historical documents, 5 witness statements and 6 evidence forms. The 6 evidence forms report that 3 people believe the route in question to be a public byway open to all traffic, 2 people believe that it has public bridleway status, while 1 person states that they have used the way as a public footpath. We've looked at the 1952 Conveyance of Land, which is a legal document for land sale purposes and not authorised record for public vehicular rights, but additionally the plan referred to within this conveyance is missing, and only an unsubstantiated interpretation can be applied to this piece of evidence. Historical planning applications were looked at, and although the planning report numbered A36666 correctly describes the route in question as a public right-of-way, it is wrong in stating that there are public vehicular rights. In a letter dated 7th of September 1988, the Highways Officer states that the route in question, along with other substandard roads in the Ndogo area, is narrow and steeply graded, with poor horizontal alignment being unsuitable for further residential development. And Mandy's going to carry on with overview of the evidence in more detail. Thank you.
Okay, just briefly, the witness statements. 5 have been submitted. Most of them record private use. Only 1 refers to Restricted Byway 24 being used by human and donkey to assist in the private transport of coal. This is verified by another local inhabitant that describes point B of the route in question being level with the properties Woodside and Priory Cottages, making the delivery of coal easier than transporting it directly up the hill. Evidence forms. 6 have been submitted, and these do not sufficiently support public vehicular rights over the route in question. The user evidence forms acknowledge that public status already exists. However, this evidence alone does not, on balance, clarify the type of public use of the route in question. Pre-order consultations dated the 28th of January 2015 to the 10th of March 2015 was sent to 37 consultees. Out of 7 user group representatives, 2 objected to the proposal to register the route as a public footpath. Out of 17 local inhabitants that utilise or abut the route in questions, 8 replied. Of those 8, 3 objected to registration of public footpath, 1 objected to registration of a public byway open to all traffic, 2 state that the route should be maintained to vehicular standards, and 2 are against the upgrade of restricted byway 24. Natural Resources Wales has replied and have no comments to make regarding CRB 20 to CRB 23. While restricted byway 24, which passes through Cledden Shoots, is subject to the regulations for a site of special scientific interest and for special areas of conservation, should any proposed maintenance or changes be made. The Land Registry documents of 2015. I have investigated 20 documents, and these have no public vehicular rights described for the route in question. There are 10 Land Registry documents for landowners that require use of Section A to B of the route in question. Out of these 10, there is only 1 document that refers to the route in question as a private roadway. All the following are discussed in greater detail in this presentation: the historical map evidence, definitive map evidence, the highway records, the aerial photographs, the site photographs, and the Natural Environment and Rural Communities Act. The historical evidence. The earliest maps were compiled by different private cartographers. This is part of the John Carey series dated between 1820 to 1832. This John Carey's map does not show the route in question. I have not been able to find the enclosure award for the Manor of Landogo. This is an extract of the award that lies west of the area being investigated. The Manor documents were also researched, and no further information was found that assists this claim. The 1823 Prices map is another map compiled by a private cartographer. This plan may only show a general representation of the routes in questions. A comparison is made between the 1823 and the 1901 OS map. Some of the alignments of the routes are misleading. The section of the route CRB 23 is not shown. The earlier 1800s maps only recorded an alignment of a route with no change in the linear markings for footpath, bridleway, or road. All Ordnance Survey maps do not record the public or private status of any route depicted. On the 1828 plan to the deed papers for Cledden Shoots, the route in question is marked by 2 pencil lines, and the route possibly continues as a footpath to the stream Cledden Shoots. The deed catalogue entry gives no further information regarding private or public rights. This is the 1830 Greenwoods map. That is another map series compiled by a private cartographer. I have enlarged the extract of the Greenwood. I highlighted the routes green on both maps. The Greenwood and the 1902 Ordnance Survey maps to assist with the comparison. You will note from the comparison that routes 23 and 24 are not shown. The Greenwoods map, when compared to other maps of the same era, show a general representation of routes and not the detail that is recorded on the more formal mapping, having only the pre-1835 Greenwoods and the Prices series map that do not clearly depict the full extent of the route in question is not enough to support the claim to register the route as a publicly maintained byway open to all traffic. The Cassini map is a copy of the 1830 OS map. This map does not show the route in question. The 1830 Davids and Charles map is a copy of the 1830 OS map. This map does not show the route in question. I have made a comparison of the David and Charles map with modern mapping and highlighted in pink the alignment of the roads in the area. You will notice that the similar patterns displayed. This comparison shows that the route in question is not recorded on the 1830 David and Charles map. The 1830 Ordnance Survey map is the original document and a better quality survey of the physical features in the area. These maps of the same era as the Price and Greenwood's map are technically more accurate. This map does not show the route in question. The 1834 plan to the deed papers for Cleddon-Shoots possibly indicates the route in question with 2 pencil markings. The mention of road in the catalogue entry does not refer to the route in question. The route in question does not continue through Cleddon-Shoots, suggesting that the route being investigated was not regarded as a major through route for the use by the public at large, on horseback or in motorised vehicle. Legislation under the 1835 Highways Act stated that if a route is shown to pre-exist 1836, it would then be maintained by the local authority at public expense. The inconsistencies shown in all these earlier maps suggest that the route in question is probably not maintainable at public expense. Additionally, the earlier maps do not support the registration of the route in question as a public byway open to all traffic, a restricted byway, or a bridleway. The tithe map is one of the more important historical documents researched. The initial purpose of the tithe maps was to serve as an official record of the boundaries of all tithable fields or land parcels on which tithe rent charge was apportioned in the schedule of the tithe apportionment. Routes shown shaded are incidental to the initial purpose of the tithe documentation and its associated map record. This means that when a comparison of the tithe maps is made with modern public rights of way or public road registers, there are in many cases routes shown on similar alignments. This suggests that other alignments that are not recorded may have public rights. However, no tithe map provides direct evidence of whether or not a route was used by the public at large. The tithe map has been turned here to match the orientation of the Ordnance Survey maps. The marking shading of the route in question ends at point A and point B. The lack of any route alignments marked or shaded either south of point A or north of point B suggests that there were no additional properties and other routes to record at that time. Additionally, the route in question was accessed via 2 other routes from the east that are now recorded as public footpaths. This shows that the route in question was only an access way for various plots and not a main public through route. The 1881 Ordnance Survey map shows the route unshaded. This is unlike the tithe map previously looked at. The significance of the shading, the 1881 Ordnance Survey map, is understood when this OS map is compared with highway records. It is then noted that only the main through roads are shaded on the 1881 map. The OS map is like the tithe map. This is because the end of the shading on the tithe map is similarly marked on the 1881 map with solid lines at points A and B. The solid lines mark physical features such as barriers or streams that cross the route in question. The conventional signs and writing used on the 6-inch maps of Ordnance Survey show the markings used to depict the physical features encountered on the ground. It is reasonable to suggest from this key that the solid lines for fence probably represent either a gate or barrier of some description, while the broken lines marking an unfenced road. The broken lines probably represent a change in surface. Therefore, at point X, there is no barrier but a change in surface. The fact that the fence structures are recorded on both the OS map and the tithe map again shows that the route in question was never regarded as a through route for all types of public user. The 1886 Ordnance Survey map, the markings of solid lines representing barrier and a stream at point A and a barrier at point B, suggests that the route in question was not a main through route for the public at large, on horseback or in motorised vehicles. The markings on this map show no barrier at point C or X. The 1902 Ordnance Survey map shows similar markings to the previous Ordnance Survey maps already discussed. However, the 1902 Ordnance Survey map does contrast in one thing, as there is now no marking representing a barrier at point A. Left of point A, there's the word spring, which suggests that a culvert was located at the start of the route in question. At the other points, B, C, X, the same markings remain. The 1921 Ordnance Survey map shows similar markings to the previous Ordnance Survey maps already discussed. Again, there is no marking representing a barrier at point A. There is still a suggestion of some type of barrier at point B. The same markings remain for C and X, which when taken together with all the other historical mapping investigated, it suggests that the route in question was not regarded as an open through road for all types of public user. The Finance Act map is another important document which is normally awarded the same evidential weight as the tithe map. The purpose of the 1910 Finance Act map was compiled to record the extent of land ownership, which provided for the levy of tax on the incremental value of all land in the United Kingdom. Fines were issued if landowners did not complete appropriate forms or make payments, the results of which were recorded as coloured areas along with the plot numbers on the accompanying maps. While in this region, routes such as shared private roads and registered public footpaths are shown uncoloured or white out. The 1910 Finance Act map shows the section between point A to B to be left uncoloured, while from B northwards the land is coloured. This suggests that A to B is probably a private shared driveway or in the public domain, while section B to C, which is already a registered public right-of-way, is shown to cross land that is recorded to be in private ownership. There are other routes shown uncoloured, which are registered as public footpaths. As demonstrated here, this map, usually helpful to determining vehicular rights, is contradictory within itself and can't be relied on as the single document to verify public vehicular rights. The definitive map evidence. The draft definitive map, sheet 21, dated December 1952, shows the route in question between A and B with a broken green line. This is the official symbol for the road used as a public path. The route is also given the non-statutory letters CRB, Cart Road Bridleway, and the numbers 20, 21, 22, and 23. Then the next section, B to C, has the same marking of a green line, a broken green line, for a road used as a public path. However, this time with the non-statutory letters Cart Road footpath, and the number 24. I was going to say CRF, but Cart Road footpath. This means that the route in question is already registered as a public right-of-way. However, the level of public rights is not clarified by the symbols recorded and therefore is being investigated. Office files have been researched and 2 letters have been found that show the route was not regarded as publicly maintained highway. The county surveyor further explains that he did not know what was meant by lateral roads and was of the opinion that these lateral roads were simply approaches to private residence on the hillside overlooking the Wye Valley. The written note here states that V. Lawrence agreed with my, that is the county surveyor's, contentions that the ways were not roads, and even if there were public paths, we ought not to do anything more than keep them open. These 2 letters and note show that the observed status for the public rights over the route at the time was footpaths. The observed public rights are further verified by the title of the definitive map. It is noted here that the word public has been crossed out and replaced by private. The word public as part of the non-statutory symbols for Cart Road Bridleway and Cart Road footpath are typed on this title in error, which means private, which leaves private to describe carriage or cart road, another error in the title. As explained by Lord Denning in the case law R versus the Environment Secretary XP Hood, that local authorities did not mean to say whether the cart road was public or private for carts, because they did not know which it was. They only meant to say by CRF that there was a public footpath along a road, and by CRB a public bridleway along a road. The addition and deletions map is part of the working documents prior to the completion of the definitive map. In the applicant's report, there is a misunderstanding between the definitive map and statement for public rights of way and the list of streets for public maintainable highway. A bold blue line over the southern section of Cart Road Bridleway 20 records the deletion of the section from the public right-of-way register, as public rights were already recorded on the list of streets. The 1967 definitive map that shows the route in question by a broken green line for a road used as a public path. This map here is not the definitive map, but is an enlargement which was compiled in 1967 to show the routes more clearly in the Landoga area. The applicants on the 13th of April 2004 have submitted a definitive map modification order alleging that the routes 20 to 23 have public vehicular rights. The definitive map and statement, with the use of the statutory and non-statutory symbols, has resulted in the public status for the route being in question being unclear. The definitive map statements were compiled by Mr. F. Williams of Wydene, possibly the previous name of Misty Cottage, in a property that is adjacent to the route in question. Public rights of way numbers 20 to 24 in Trellick starts on the county road west of the Mount, rough surface road, passing through wood as far as Young's Cottage, continuing as unsurfaced road for a quarter of a mile approximately, with a turning point for lorries at the end. Road now continues as a cart road footpath crossing Cledden Shoots into Cloisters Lane near Marigold Cottage. The first part of this description refers to the county road C40-7 as a rough surface road. I am aware that Young's Cottage is now Bargain's Cottage. The second part refers to the route in question, CRB 20 to 23, as unsurfaced road. The third part refers to a turning point for lorries at the end. This is descriptive of what is physically seen and does not suggest public vehicular rights. A local inhabitant has reported that the lorry was the size of an original Mini and the length of a Ford Mondeo. Additionally, as the local co-merchant lived along the route in question, he needed the use of a small turning area north of his home, Glencote, to store his coal and to turn his vehicle. This is a record of private vehicular use of the route in question. The fourth part refers to the route in question, restricted Byway 24, and State Road now continues as a cart road footpath crossing Cledden Shoots into Cloisters Lane near Marigold Cottage. The definitive map statement frequently uses the word road. It is incorrect to assume that this descriptive term road automatically stipulates that such a route should have public vehicular rights. The definitive map statement, the other existing public footpaths have statements that give further description regarding the route in question. You will note that 3 of these statements refer to the route in question as Glen Road. As Glencote is the name of the property at the northern end of the route in question. The descriptive term Glen Road does not make this route a public highway maintainable at public expense. Please note that it is from these definitive map statements that the whole area is referred to as Great Hill and is not attributed to a single dwelling as proposed by the claimant. I'll take this opportunity to discuss the 1952 conveyancy documents, Chapter 5 of this report. The plans used here are not included, and the conveyancy documents are not included with the conveyancy documents. This 1952 conveyancy document has no weight as the original plan is missing. However, to fully understand this conveyancy document, I have used the 1881 and the 1921 Ordnance Survey maps to assist with the location of Rock Cottage. Today, this property is named Leckenbeck. The 1952 conveyancy documents for Rock Cottage. All the land in Landogo, together with the dwelling house known as Rock Cottage and all other buildings, all of which form part of the enclosure, numbered 653 and 654 on the 1921 Ordnance Survey map, and are shown on, of course this plan is not included, the plan annexed and edged red along with a written description which was in a conveyancy dated the 3rd of December 1887. The extract from the 1887 conveyancy documents included with previous documents for Rock Cottage all the land, orchard, garden and premises and Landogo bounded by the properties belonging and by the public road leading up to a place called the Great Hill on all or most parts inside, and a small portion of property that is intersected by a road leading from the Trellick Road through the same property to a place called Glyn All, plot numbered 679. This map is the 1881 Ordnance Survey map and not the tithe map as incorrectly described in the title deed. The tithe map has different plot numbers and plot 679 is not marked. The applicant states that the property conveyed is described as being bounded by the public road and leading up to a place there called Great Hill. In the 1952 conveyancy, the public road that bounds Rock Cottage land may possibly be 2 routes, which both lead from the Trellick Road, that is east of the route in question. The main routes up to Great Hill area proceed from the north, east, and the east, and continue in a westerly direction. If this document does refer to all the roads that lead to Great Hill area, it does not include a section of Cart Road Bridleway number 23, that bit there. The 1887 conveyance of the land for Rock Cottage mentions public road, but does not specify the type of public rights. The investigation is not into whether or not public rights exist. It is type of rights that are being decided. Already there are numerous public footpaths crossing the area. Due to the missing plan and the incorrect plot reference numbers, the proof and the weight of this historical document is weak, and only an unsubstantiated interpretation can be applied to this document. The highway records. Is there any questions so far? Or shall I carry on? We will continue with the highways mapping. Please turn to chapter 13. This is the 1949 highway map document. The extent of the publicly maintained highway ends at point A. This is the 1949 map, which is older than the 1952 definitive map records. In other words, the extent of the highway to point A preceded the definitive map survey. You will note that on the extract of the draft definitive map, the section crossed out was previously shown on the highway records. Both highway maps show the extent of the highway to end at point A. On this 1921 larger scale Ordnance Survey map, it is noted that at point X, the broken lines suggest a change in surface. These broken lines on either side of the east and west route up the Great Hill may not denote barriers across the route in question, but when taking all the historical maps discussed, the 1952 conveyancy documents, along with the clarity of the 1921 Ordnance Survey maps, it is noted that the route in question is not the main route up to the Great Hill area. It is instead noted that the east-west route is the main route up the hill, which was with other markings that indicate steps, making it unsuitable for horses or motorized vehicles. The aerial photograph dated the 13th of April 1947 shows a small triangle of lighter grey shading. This is evidence of a turning circle for vehicles, mostly on private land, and is probably that which is described in the definitive map statements. There are markings that suggest the continuation of the route in a northwesterly direction through the woods. When requesting these photographs from the Welsh office, I had an opportunity to view these through the stereograph, and I'm able to report that CRB 23 had a rougher surface when compared to the more frequently used surface of CRB 22 and footpath 18. This shows that the section of the route in question near Glencote was not regarded as a main through road, in contrast to the route in question. Furthermore, footpath 19, east of Glencote and descending the Great Hill area, is shown in greater relief, suggesting that footpath 19 was used more frequently as the main route to ascend and descend the hill. And because of this daily use, the route probably became more eroded and thereby more marked than the other ways that run parallel with the contours of the hillside. The aerial photograph dated the 13th of April 1947, showing the northern section of the route that passes through the woods, making it difficult to make out the alignment of the route. Although it is possible to determine that it's probably that this is probably the location of point C. The aerial photographs dated the 27th of March 1970 shows the route in question vividly in a medium grey shading, and when viewed through a stereograph, a grass knoll is seen in the middle of CRB 23. This suggests irregular vehicle use of the route in question. It is noted at point B that there's a barrier of some description was located to prevent some type of use. At the same time, the photographs show another larger turning area directly north of Cledden Stile, being more evident 19 years after the 1951 definitive map survey, which suggests that the larger turning area was required for private land management. The tree canopy is too dense to assist further in the investigation of the usage for CRB 24. The aerial photograph of August 1972 shows the tree canopy is again too dense to assist further in investigation of the usage for restricted byway 24. This is part of the selection of photographs taken over the years. Additionally, as part of this presentation, I have only chosen a few photographs. Please turn to Appendix 51, where you will see this photograph associated with a plan of the route in question. This photograph shows you a landslide from the property above the route in question. This shows that the Great Hill area is prone to this type of land movement. Please turn to Appendix 52. Repairs to the wall were made by the landowner, Mr. Thomas of Rose Hill. Reports repairing the wall, which is for the purposes of retaining his property. You will note that there is evidence of wider vehicular use of the whole width of the route in question. It is stated by the landowners of Cascades and Bodmin that the wall bank that retains the route in question is not their responsibility. Please turn to Appendix 53. This is a picture of the potholes in the surface of the routes in question that caused Mr. Greggins to complain to the authority to surface the route. It is possible that the combination of the broken wall, the weather, and the use of the route in question by wider vehicles has caused the damage to the surface. The public use of this route is not what has caused damage to the route. Please turn to Appendix 54. The authority has agreed out of court to provide a surface for Cart Road bridleways 20, 21 and 22 on the basis that there was no acknowledgement on part of the council that public vehicular rights exist over the route in question, and that the council were not responsible for maintaining the same to the standard suitable for public vehicular use. The landowners of Cascades and Bodmin state that this surface of the route in question has now invited wider vehicles to use the route and are therefore damaging the verge and placing added weight on the wall bank that retains the route in question. The witness statements and evidence forms list numerous visitors such as family and friends, deliveries such as posts and parcels. These are people that have gained access by invitation of the local inhabitants and not representatives of the public at large. This is a section that is marked as CRB 23 on the definitive map. The grass knoll in the centre of the route in question was also seen on the 1970s aerial photograph, it is noticed that the worn parallel tracks have been formed by motorized vehicles, evidence of vehicular use. However, other evidence already discussed shows that this vehicular use is not the public at large, and over 34 years there has not been any extensive use of the route, causing deeper ruts to the surface. Please turn to Appendix 55. Proceeding northwards on the start of this section marked Restricted Byway 24, you will note that the worn parallel tracks do not continue to the field gate. This shows that the frequent use of public vehicles have not proceeded to this point or beyond. The public right-of-way continues past the gate to the left of the photograph. Along this section of the route in question, the obvious use is walking. Furthermore, on the office file for Restricted Byway 24, there are no complaints from either equestrians, cyclists, or motorcyclists suggesting that the route in question was only utilized by walkers. Please turn to Appendix 56. The office files have no communications relating to complaints made by equestrians or motorists about the stepping stones, making Cleddon Chutes difficult to cross. This photograph shows the narrowness of the route, again supporting the fact that the route in question is not a public through road for equestrians or motorized vehicles. This is now a selection of photographs taken in 2014. There is now a garage for Bargain's Cottage at point A of the route in question. The inhabitants of the area mention that the continuing permitted development is opening up the route in question to more vehicle usage, which is causing damage to the wall bank that retains the route. There is very minor damage to the verge at this location. It is possible that the route in question is wider here, or vegetation has had a chance to recover as the vehicle use is low. This limited damage to the verge suggests that the public at large do not use the route in question in motorized vehicles. Still on Appendix 57, the evidence of use is that of motorized vehicles with the wheeled worn parallel lines over section CRB 23 of the route in question. I have previously spoken about the central grass knoll, which to date remains unchanged. For your information, a route that goes downwards to the right of the photograph is a registered public footpath. The council surfaced part of 2021 and 22, and I'm not aware of the full extent of what was surfaced. I'm not able to confirm if a landowner from further down the way made private arrangements. You will note that the vehicular traffic is not evident along this section. Under the definitive map evidence, I previously described the ambiguity of public right-of-way symbols for the map. There is currently on site a restricted byway sign. I'm sorry, it's not very visible on my photograph, but it is there. The 2000 Countryside and Rights of Way Act and the 2006 Natural Environment and Rural Communities Act have changed this route from a RUP, a cart road footpath, that is essentially a public footpath, to a restricted byway, which means that this order, if made, will revert the registration of this route to a footpath. Please turn to Appendix 58. This section is Restricted Byway 24. Only footpath use is evidence here, as the surface is not poached by other user types, for example, equestrian. Please be aware that in determining such claims, need, nuisance, suitability cannot be taken into account. However, is this route open to a horse and also horse and cart use? If so, there is no complaints on office files from cyclists or equestrians requesting that this be made safe for the type of public use. Furthermore, there are no complaints on file regarding the fallen trees. The lack of complaint on file supports the fact that public vehicular, equestrian and cyclist rights are not utilised over this section of the route in question. More evidence that this route has been regarded as a public footpath. If vehicular, equestrian and cyclist use had occurred on a regular basis, then this soft surface would be more deeply poached. Continuing northwards, there is additional evidence that the route in question is not open to all different users listed. The route, restricted byway 24, proceeds between two old stone walls. This ancient physical evidence supports the fact that the route in question was not regarded as a public through route for motorised vehicles, horse-drawn carts, horse riders and cyclists. Instead, the route was and is only used as a public footpath. The 2006 NERC Act. The Natural Environment and Rural Communities Act 2006 came into force in Wales on the 16th of November 2006. That means that because of the valid 2004 Definitive Map Modification Order application for the route in question, A to B remains incomplete. The tests under the NERC Act do not apply, and mechanically propelled vehicle rights are not automatically extinguished by the Act. The outstanding Definitive Map Modification Order requires, as part of the order-making process, an investigation into all the available historical documentation in determining the level of public status for the route in question. The commencement of the relevant sections of the 2000 Crow Act and the 2006 NERC Acts have changed Cart Road Footpath 24 to restricted byway, allowing all user types except motorised vehicles. The investigation has shown that, with the assistance of these test questions under subsection 67.2 and the investigation into all the available historical documents, that the whole route A to C does not have public mechanically propelled vehicle rights. A summary for section A to B. The applicants seek to upgrade the status of public cart road bridleways 20 to 23, points A to B, to a byway open to all traffic. The applicants claim that the route recorded as one type of highway should be recorded as a higher type. In considering this definitive map modification order, the committee needs to decide whether or not public vehicular or equestrian rights also exist, and in doing so cannot take into account need, nuisance or suitability. Investigation into all the available documents shows that the route in question has not been utilised by the public at large with either vehicular or equestrian rights, and should be recorded as only having public footpath rights. There are a few reports of equestrian or vehicular use along different sections of the route in question. These reports give no support to public vehicular or equestrian rights. Study of the 1952 conveyance of land for Rock Cottage does not support public vehicular rights. Planning permission reports do not have the legislative weight to make the allegations regarding any public rights. The planning report A36666 is incorrect in stating the type of public rights. A consultation letter from the Highways Department within the planning bundle for A29567 states that the route in question, along with other substandard roads in the area, is narrow and steeply graded, with poor horizontal alignment, being unsuitable for further residential development. The witness statements all refer to private vehicular use, such as the invitation of friends, family, and utility providers. This does not represent the public at large and gives no support to public vehicular or equestrian rights. The 6 evidence forms, like the witness statements, do not support public vehicular rights or make any reference to public equestrian usage. The consultation shows that the route in question is not regarded as a public vehicular thoroughfare. Additionally, in a letter dated 1988, it has been reported that the access road is not adopted, its maintenance is the responsibility of the adjacent landlords. The early historical maps, such as the 1823 Prices, the 1830 Greenwoods map, the 1828 and the 1834 title deed plans for Cledden Shoots, are all insufficient in evidence to prove that the route in question should be publicly maintained as a byway open to all traffic, restricted byway, or a bridleway. The strict production of the 1830 Ordnance Survey maps and the better quality copies of the 1828 Cassini and the 1830 David and Charles maps do not show the route in question, therefore do not lend their support to public vehicular or equestrian rights or to the maintenance of the route at public expense. In this case, the usual convention of the colouring of routes on the 1846 Tithe map and the non-colouring of the same on the 1910 Finance Act map does not support public vehicular or equestrian rights over the route in question. The 1949 Historical Highway map is the earliest recording of the highway C40-7, and therefore this section did not need to be registered again on the definitive map. The adopted highway ends at point A, showing that the route in question was not recorded as an adopted highway. The 1940s aerial photographs viewed through the stereograph show the different surfaces of Cart Road Bridleways 22 and 23 prior to any recent surfacing work. This shows that the route in question is not considered a main through road for public vehicular or equestrian use. The site photographs dated 1998, 2004 and 2014 depict Cart Road Bridleways 20 to 22 to have a more recent sealed surface. The 1940s aerial photographs and the 1952 definitive map statement confirms that the Cart Road Bridleway 23 has never had a sealed surface. The outstanding 2004 definitive map state modification order for the route in question between points A to B is not subject to the tests under the 2006 Natural Environment and Rural Communities Act. However, by applying the NERC tests to all the historical documentation as part of the investigation, it shows that the route in question does not have public vehicular or equestrian rights.
Just to clarify, route A to B, we are talking about Cart Road Bridleways 20, 21, 22 and 23 as shown on your plan. If you want a copy of plans, please raise your hand and I'll bring them round.
Ruth, we're starting to talk about the next section, B to C. Yeah. This is the summary for Section B to C. Prior to the commencement of the 2006 NERC Act, the authority should have carried out a review of the definitive map and statement, particularly investigating roads used as public paths, and by order show every RUP as a byway open to all traffic, a bridleway or a footpath. This was not done. In considering the claim for public vehicular rights for Section A to B, it was deemed best practice to look at the entire route A to C, thereby investigating all the historical documents just the once. So we had to look at A all the way through to H, now that you've got that map in front of you. But I am going to speak specifically from points E to H now. Section B to C is marked on all the Ordnance Survey maps as an unfenced minor road and has in fact not been used as a right of, not used as right by the public at large in vehicles, in a horse-drawn cart or horseback or on a bicycle. The applicant's report does not address Section B to C of the route in question, and therefore some of the evidence submitted has no influence on this section. The consultations report that the landowner of Cledden Shoots mentions some motorbike activity, which is difficult to assert if this is public use with vehicles or just a single occurrence of antisocial behaviour. One account of vehicular usage does not support public vehicular rights. On the whole, the consultation revealed a general lack of opinion, and this, along with the historical map markings and other documents, lend support to the route being a public footpath only. The 1823 Prices map is the only historical map that suggests a route crosses Cledden Shoots, and at the same time does not record Cart Road Bridleway 23. On comparison with other historical maps, the alignments of routes shown on this map do not relate correctly to the alignments marked on the 1820s OS maps. The 1828 and the 1834 title deed plans for Cledden Shoots and all the 1830 historical maps have no markings that indicate a route that continues through Cledden Shoots. Therefore, these historical records do not support any public vehicular or equestrian rights through Cledden Shoots. The 1846 Tithe Map and the 1910 Finance Act maps and their associated registers do not record any type of route through Cledden Shoots, and therefore do not support any public vehicular or equestrian rights between points B to C. The 1881, 1886, 1902 and the 1922 Ordnance Survey maps all show Section B to C as a minor unfenced road. The 1922 Ordnance Survey map has the symbol FP alongside the parallel broken lines. These symbols and markings for this section shows that this part of the route has the status level of footpath only. The definitive map and statement is supported by a strictly followed legislative process. Section B to C is marked by a broken green line for road used as public path, RUP. Case law states that the other symbols, CRB and CRF, are non-statutory, as the local authorities did not know whether or not a cart road was public or private. The historical highways map and aerial photographs for Section B to C give no further supporting evidence. The site photographs dated 1998, 2004 and 2014 show the route in question as a non-surface track. The photographs proves that the route is not regularly used by motorists, equestrians or cyclists, as evidence of use is not shown, which leaves only public footpath rights. B to C is affected by Section 67(1) of the 2006 Natural Environment and Rural Communities Act, and all public mechanically propelled vehicle rights are removed, changing this section to a restricted byway. Contrary to that legislation change, all the historical evidence suggests that on the balance of probability, this route is only a public footpath. In conclusion, there is a single mention from a local inhabitant with regards to the public vehicular use and the single report of antisocial motorbike use, which are both not sufficient to register the route in question as a byway open to all traffic. All the reported use, either in a vehicle or on a horseback, record private needs, such as the private transport of coal. Such usage does not support the entire route being recorded as public byways open to all traffic, restricted byways, or bridleways. It remains on balance with all the evidence researched that the entire route investigated does not have public vehicular, horse-drawn cart, equestrian or cyclist rights and should be registered on the definitive map and statement as public footpaths and maintained to the level required for that type of use.
Do you have any questions? Would you like to see any of the original definitive map documents? We have them out the front here, and some aerial photos and the Cassini map.
I assume you're in the discussion mode now then. So first of all, I'd like to thank the officers for quite a comprehensive presentation and the way you've done it. It was very clear to understand what you were looking at and the evidence presented, so I congratulate you on that. Access to private residences. I mean, on Route A to B, I mean, we saw there some tarmac-adam roads, didn't we? Right? So I assume those would have been laid by local landlords and to gain access to properties, whatever, on their own land. I assume that's the case. And when we say that, I mean, a lot of evidence points now to the fact that it's a footpath. But if it is declared formally as a footpath now, how do the local inhabitants stand there? Because obviously vehicles are using that part of road. I mean, are they still eligible to use that road as a private access, even though it's declared a footpath? That's the first question. And the second question is, have there been any other surveys done as such to determine if there is any public use of the paths in question? That's the two main questions.
Private rights would still be maintained regardless of what status we give the right of way. So that's the first question. So that would be unaffected. We wouldn't be affected any private rights at all. Regards to the surveying, now we've carried out 2 consultations in the local area, which include user groups and the community council, numerous amount of people, but we didn't have any real feedback from anyone on usage. We know it's quite well walked, that area, and there's evidence on that on ground. You can see footprints, and I've met people up there walking. But we didn't find any documentary evidence or evidence from people themselves saying they've used it in any other manner. We don't have monitors or counters up there to show what different types of use there could be, because they don't really exist. If we had one, it would record vehicle numbers, but it wouldn't say whether that was private or public. So we haven't been able to do that.
I think the other observation I've got, and it's a very important statement you made there, that utility access is not considered to be public access. I mean, that's very important differentiation there, because obviously you get coal lorries, postmen, milkmen, double glazing men or whatever, gaining access to a property, but that's not public. That doesn't determine a public right of way. And I think that differentiation is important.
Page 16 on the second order. At the top, it would be paragraph 611. There's a representation from Mr. Ashley Thomas. I'm presuming that's Ashley Thomas. Yeah, right, it was right. So he's been resident there since 1949, or yeah, it'll be about right. How much weight should we put to where it says in the line, then in the late 60s when car usage increased, the residents joined together, commissioned by a local contractor, and then tarmac from point A to junction of CRB 22. Does that suggest that was always something that they would always maintain themselves?
Sorry, that to me means that it was privately maintained, and they took it upon themselves to share that private maintenance.
And then on 612, it basically describes the condition of the route beforehand.
Yes.
Before it's tarmacked. Okay.
Is there any further clarifications or questions regarding specific maps? From the members?
I think the officers are to be congratulated on the report that they brought before us. It's been really explained in full, and I really haven't got any questions I need to ask. I don't think it's really up to the committee, I think, to decide what we should do now.
Oh, sorry.
I'd just like to say to the members, before you decide now and considering, you need to weigh up the evidence, obviously, as your role was judicial, and you know it's something you must take into consideration in deciding upon the evidence. Now, this is done on the balance of probabilities, so you need to weigh it up. But also, as well, you must, these routes are already recorded on the definitive map and statement. So you're looking at the status of these routes. So you need to make sure that you've looked at the evidence in making your decision and recommendation. So I invite you now to resolve on the balance of probabilities whether or not you believe that the evidence presented shows that the cart road, bridleway and restricted byway should be registered as footpaths. And then obviously giving the advice to the Community Services Cabinet portfolio member in authorising the making of these modification orders, being the two separate routes that we've looked at. But you need to be satisfied.
Could I ask the officers just to clarify once more the difference between a footpath and an unrestricted bridleway? Byway, sorry. I get it wrong. A footpath and an unrestricted byway as presented during the discussion you put forward there with that signpost, etc. So I just like to differentiate for people watching the difference between the footpath and the unrestricted byway.
A footpath is for use on foot only, and a restricted byway is for use on foot. You come and on horse and cart and with a bicycle. That's the difference between the two.
Are you satisfied with that explanation? We've got in our pack here the recommendations in view of which way we want to go forward. Can I ask members to look at that recommendations and to say if they agree with it and to contemplate the reasons, and if they disagree with it, also to be thinking of considering why that this recommendation, we would go against this recommendation. I'll read it out. That the Rights of Way Advisory Panel, which is ourselves today, advised a Cabinet Member for Community Development to make a modification order under Section 53, Part C, Part 3C, Number 2 of the Wildlife and Countryside Act 1981 to clarify the cart road bridleways 20, 21, 22 and 23, which is the path A to B, and restricted byways 24 as a footpath, and to confirm or seek confirmation of the order. The details of the case are included in the report Appendix 3, which we've all had a sight of and also been presented here today in great detail as part of the background papers. Maybe if I can ask for a show of hands, are we